second case on this morning's docket. It's case number 111698, State of Kansas v. David Rice.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers and respectfully requests 3 minutes for a vote.
3 minutes is granted.
In this case, Rice was lawfully arrested for driving under the influence, but he refused to take a requested breath test to determine his blood alcohol content. He was then charged with refusing to take that breath test. At issue in this case is whether the state's criminal statute is constitutional in light of Birchfield v. North Dakota. In Birchfield v. North Dakota, as this court is aware, the United States Supreme Court held that a search incident to arrest, if done for an arrest for drunk driving, is lawful and there is no right to refuse such a search. So now there are 2 ways to uphold the criminality of the state's statute at issue. First, this court can reinterpret how the statute was interpreted in the original opinion in Rice, and this court can find that the statute criminalizes the refusal to search rather than the withdrawal of consent. Or this court can recognize that the 2 are basically a distinction without a difference because there is no lawful right to refuse. As this court knows, it has an absolute duty or obligation to uphold the constitutionality of a statute if it can do so, and here we are talking about a facial challenge. The state has to prove that some target of the statute can be constitutionally punished, and here that target is a search incident to arrest, or the refusal to comply with the search incident to arrest. The action that the statute seeks to criminalize is the refusal. It uses the word refusal or some form of that 3 times. It talks about deems consented to once. The deemed consented to modifies not the action that is being criminalized, but the type of test at issue. So here, the blood, breath, or urine. There's a legislative definition of refusal that's in 1013I, and it does not talk about consent or the withdrawal of consent at all. And then the legislative history supports that interpretation, as well as Justice Stiegel's dissent. But the legislative history talks about wanting to punish a criminal refusal. Nowhere did any proponent talk about wanting to punish the withdrawal of consent. So if the statute is interpreted in this manner, then it's a lawful statute, and we can criminally punish a refusal after a person is arrested for drunk driving. But even if this court decides not to change its interpretation, there is no practical difference between a refusal or the withdrawal of consent when there is no right to consent. Under either one, the statute is not punishing anything that is constitutionally protected, and thus it would be lawful. There would be no due process violation or Fourth Amendment issue with the statute. There are no questions.
Would there be a statutory violation? I mean, because the statute, the state can limit circumstances in which procedures can occur, and it can be more limited than what the Constitution would allow. And does the wording of the statute allow it? There is no, for example, when you look at the informed consent statute, it does not give the law enforcement officer the power to direct the completion of a test except in one limited circumstance, and that's the blood test that Birchfield now tells us is unconstitutional. Otherwise, the statute only empowers the judge or the law enforcement officer to request the completion of the test.
Right, and that's all we need for a search incident to arrest is we request you complete the test. We can't actually force someone to take a breath test. If they say no, we're going to have to punish them for criminal refusal or have to go get it through some other way. The state cannot force anyone to take a breath test. It's the way the test works, it is physically impossible to force it. So the legislator wouldn't have written in there that there's some way to force a breath test because it simply can't be done. You have to exhale air for a amount of time that we can't physically make someone do that. So I think the statute, subsection KSA 1001B talks about basically a search incident to arrest, and that if they are under arrest and they have probable cause for driving under the influence, they get to request the test, and that would then kick in a search incident to arrest because that is what a search incident to arrest is. We say we're going to take this test. They can either say no and be punished because they've refused, or they can agree to take the test. Am I making sense?
Does that conclude your presentation?
Yes, Your Honor, if there are no further questions.
Any more questions? Thank you, counsel.
Thank you.
May it please the court, Patrick Dunn, Deputy Appellate Defender, here today on behalf of David Rice. And I might have a little bit more to say than Ms. Chalmers. First of all, anything I don't reach, I'd still go ahead and submit on the prior briefs, including the originals. First, with respect to the plain language of the statute, of course, we feel that the court reached the correct decision first time around on this. We look at the plain language of the statute, which is always what is paramount. We look at what it says, and it says refusing to submit or complete a test deemed consented to under subsection A of 8-1001. It doesn't end with refusing to submit or complete a test. There is more to the statute. So it's not any test out there. It's only things deemed consented to. If you then go to the referred section, 8-1001A, although as the dissent accurately pointed out, it allows for any kind of qualitative or quantitative testing. That testing is not allowed unless it is subject to the remaining portions of KSA 8-1001. And KSA 8-1001 does not allow or provide for any constitutional provisions, at least, for getting a search warrant. And in fact, even the section the dissent referred to, 8-1001P, is not actually a search pursuant to 8-1001. It just is an exemption from 8-1001. And the more I thought about this, I think Webb, which I've mentioned in my 609, referring to the incriminating statements, the Fifth Amendment argument, I think Webb might have some implications here too, because Webb says, okay, you can go ahead and get a search warrant. Well, that's nowhere inside 8-1001. That's not a search. The court recognized this in Webb. So it's not a search inside 8-1001. So if there are searches outside 8-1001, those aren't the searches that are being punished by the plain language of 8-1025. Looking at the legislative history, we've always had conditions to 1001, and it has always involved testing deemed consented to. I think the plain language has always required that. And even when the provision allowing searches outside 8-1001 was added, the amendments in 2008, those still, again, as I said, are not searches within 8-1001. With respect to the history of 8-1025, it's pretty clear if you look at all the proponents, whether it be Ed Klump, Mark Bruce, Steve Howe, their testimony was it's really a tool to coerce consent. It's not punishing not submitting to any testing at all, not submitting to warrants, not submitting to... Nowhere did any of that testimony mention warrants. Nowhere did any of it mention search as incident to arrest.
Can't that be? can't coercing consent be understood in two very different ways in the context of forcing somebody to submit to a breath test? And the case law talks about this, right? There's legal consent, and then there's just, you're not going to go in kicking and screaming. You're going to submit, physically submit to the test. And isn't that really what the legislative history shows? Is this is about getting individuals to orderly and without fighting the officers.
No,
In a
I
safe
don't think so
manner.
at all. I think it's all about getting to agree to consent. I mean, this goes back to this court's prior cases, back to Brister, back to Garner.
So you think that the people that you just recited testifying in front of the legislature were talking about the legal concept of consent as opposed to simply physical submission?
Yeah, their goal was for people to give legal consent to the search, because that makes things easier for them if they have that legally consented to search.
Well, Birchfield says it doesn't, right? It doesn't make it easier for them. What makes it easier for them is the physical submission of the defendant, not the legal status of consent, because they can do this. And now Birchfield says clearly they can do this as a search incident to arrest. So it doesn't make it easier for them as a legal matter. It does make it easier for them as a physical, practical matter.
With all due respect, you're overreading Birchfield. And the state is too. The state forgets one crucial aspect of Birchfield, which I was planning on getting to in a few moments. Birchfield is a search incident to arrest exception. It's not a when you're stopped for a potential DUI exception. And if we look at the Kansas statute and we compare it to the statutes in North Dakota or the statute in Minnesota, both of those statutes require an actual arrest.
Right.
Or probable cause. We do not.
I understand that. What I'm really driving at is trying to understand, this is an argument about legislative intent and what the testimony in front of the legislature was really about. And your position is that testimony was really about getting legal consent, because that makes it easier for the state. And I'm just suggesting that there's another interpretation, at least, of that testimony, which is what makes it easier for the state isn't lawful consent. It's physical submission. And I understand you don't agree with
that.
that.
And I understand if our statute was propounded post Birchfield, that might be the case. But no one was thinking about search incident to arrest at the time our statute was enacted.
Does that matter?
Of course it matters, because we're thinking about if you're asking what the intent was of these people when they're giving their testimony, and if they had no concept that it was legal under a search incident to arrest.
Just a second. Do you think Birchfield changed the law with respect to searches incident to arrest?
I think it did.
Okay. You see why that would make a difference, right? Because
Exactly.
if it didn't change the law, it just elucidated the law, then that law was in effect at the time the statute was passed.
Then we could hype up, we could try and get into the minds of the proponents of the testimony. But I don't think nowhere did any of those people mention in any of their testimony search incident to arrest at all. And given the fact that I think it was kind of a surprise to most people the way Birchfield came out, I think we can safely say that no one was thinking about it. And if no one was thinking about it, we can't now retroactively give them, this sort of idea. Now, one comment I wanted to make before I move into talking about Birchfield is the state cites to 8-1013 for the definition of test refusal. Kind of the problem with that is 8-1013 does not apply to 8-1025. It specifically states in the opening that KSA, that it applies the limiting the definitions to follow 8-1001 through 8-1010, 8-1011, 8-1012, 8-1014, 8-1015, 10-16, 10-17, and 10-18. Conspicuously absent is 10-25. And I think one of the fundamental rules of statutory construction is that when the legislature mentions one thing and omitted another, it knows what it's doing there. And therefore, that definition does not apply to KSA 1025. It necessarily means something else. Furthermore, 1025 gives a more specific statutory definition, And as we know, when there is a more specific statutory definition, that controls over the more general statutory definition. It's a fundamental rule of statutory construction. And I would have replied to the state that I wasn't, due to the briefing schedule, that was not a possibility. Finally, it would be now, in light of Birchfield, possible for the state to correct its statute. And it could be something as simple as refusing to submit to a test to determine the presence of alcohol or drugs is refusing to complete or submit to a lawfully authorized test to determine the presence of alcohol. It could be fixed that way. I still think that would bring up a whole other can of worms of what problems there are. But with respect to just the statutory definition, I think that's okay. Moving to Birchfield itself, as I mentioned, Birchfield allows for a breath test whenever there is a valid search incident to an arrest. A necessary predicate to a valid search incident to arrest is an arrest. And as I said, North Dakota and Minnesota both have that in their statutes, that you automatically, at the time a test is requested, and a search incident to arrest would apply, you either have probable cause for the arrest or you actually are under arrest. It still also has for the unconscious provisions, but that's an implied consent situation, which is irrelevant because you're not at that point looking at a search incident to arrest. But
do you know of any circumstances where somebody's asked to submit to these tests when they're not under arrest?
Sure. And in our situation, it's when you just have reasonable. You're in custody. Our statute says you are either under arrest or otherwise taken into custody. Well, you can be a custodial situation is a Terry stop. You don't have all the facts, and in fact, when we look at what we're talking about,
just practically, and I may not know this, so educate me. How would the state administer one of these tests during a Terry stop?
No, you have reasonable suspicion that someone has been operating a vehicle under the influence of alcohol. And that's all you need under 1025B. You don't need that they were operating a vehicle to a degree that would render them unsafe to operate a vehicle, which is what the crime is. And to have probable cause, you'd have to have that aspect of it. But with just reasonable cause, our courts have interpreted that as something less. So
You're talking about the field tests that are given.
No, I'm not talking about. I'm talking about
Somebody brought in
the implied consent says whether you're either arrested or in custody. And a detention is custody. You're not free to. Custody is when you're not free to leave. A Terry detention, you're not free to leave. So
the persons that, and again, this, I'm not asking.
And those occur all
I'm
the
not
time.
asking a gotcha question. I just am trying to. Your position or what you're saying is that persons who are transported back to the facility where the testing equipment is and are given the test may not be under arrest. That's what you're saying.
they may not be.
Okay.
I also might add that we're not always going to the jail. Wichita has mobile bat vans, which always makes me think of Batman. I'm sorry. So I know Shawnee County has them. So these vans come to you. You're there. And I'll admit, Justice Stegall, when I first was looking at the stat, I'm like, when are you in custody that you're not under arrest? And then someone mentioned, well, anytime there's a Terry stop or some sort of other sort of stop. So you're not always under arrest. And you're certainly, if you're under the provision for just being in an accident, that's not probable cause for a DUI. So we don't always have an arrest in Kansas. So Birchfield can't categorically apply in Kansas under those circumstances. And one thing I'd also add is that Birchfield reaffirmed that you cannot legislate away consent. Now, they didn't have to deal with that in terms of a breath test. They specifically dealt with that in terms of a blood test, but the exact same rationale applies. There's just some things you can't legislate away. So one of the other, given the fact that we think the court was correct the first time around and that we criminalized consent, Birchfield does not even apply because that's criminalizing a search incident to arrest. That's something outside our statute, so therefore Birchfield doesn't make any difference. And that's under Patel. Furthermore, neither North Dakota or Minnesota makes any mention of a test deemed consented to in their statutes criminalizing refusals. Now, with that in mind, I'd also like to move to something that concerns me, and that this might be a good time for the court not to follow the United States Supreme Court. Granted, we haven't done that, according to my research, in a little over 25 years. But if we look at Birchfield's analysis, it's just flawed. And part of the problem, with all due respect to the attorneys and the court, is that, and this is part of the thing with DUI laws, some people don't understand, it's scientifically complex. We're looking at Henry's Law, which is closed systems.
Can I just stop you right there?
Sure.
I'm curious, how is it we could not follow Birchfield if we're talking about a question of constitutional law?
I'm talking about Section 15 of the Kansas Constitution Bill of Rights, which
You didn't make that clear.
I mentioned before. No, that's what I meant. We cannot, as we know from the United States Supreme Court precedent, we can't say the Fourth Amendment in Kansas means more than it does elsewhere.
So it's really, your argument isn't that we shouldn't follow Birchfield, it's that we should interpret the state constitution to provide greater
Exactly, and I'm
protections.
sorry if I wasn't clear on that. That's what I mean, and I'd raised Section 15 before also. But when we're talking about a breath test, we're talking about the air that is the very bottom of your lungs, right next to where your capillaries are exchanging oxygen directly into the blood. When you blow out that air in your mouth, that's not a valid sample. Henry's Law says that in a closed system, the ratio of air to a substance is equal to the ratio of the liquid in the substance. So the liquid being blood in these circumstances, the air in your lungs, obviously. And this is, and I pointed in my supplemental brief to a prosecutorial tutorial on breath testing, so it's not something that I felt like that was something authoritative enough. If prosecutors use it, then it should be good enough for the court. But as a practical matter, and the court even noted, when you're blowing, you need a good 12 seconds or so because you have to purge mouth air. And the reason is mouth air contains higher alcohol than what is a deep lung sample. And in fact, these machines will give an invalid sample, which during the course of the blowing, mouth air comes out, the alcohol level spikes, then it will drop and reach a plateau where it goes on. And that plateau is where you get that deep lung air. And that deep lung air is what gives you the valid measurement. So the court's analogy was to blowing up a balloon. Well, no one sits and takes 12 seconds taking a deep gasp and blowing into a balloon. That's just not how things happen. It was just not a fitting analogy. Next, the court claimed that air just gets exhaled eventually. Well, true, we do exhale. Every breath we exhale, but we don't necessarily exhale our deep lung air. People don't walk around gasping every time they breathe. That's not how things work. That's just unhinged from reality. And finally, the court claimed that people do not have an emotional attachment to air in their lungs. Well, I think the chewing gum and breath mint industry says otherwise. It's an entire industry built on people's concerns regarding their breath. It is something that people have an interest in. The court next says breath testing is no more intrusive than a DNA sample or fingernail scraping. But both of those things occur instantaneously. Breath testing, as we know, there is a mandatory 15 to 20 minute deprivation period. This is not instantaneous. It requires a dedicated machine, which, as Justice pointed out, frequently requires a trip to the jail, which is not instantaneous either. And even in the situation when there's a mobile van, this is not something that is inconspicuous, as there is a van on the side of the road that you have to go into and undergo this testing. And finally, breath testing is not limited to just blood alcohol content. Breath tests can and are preserved. And it was kind of strange when I read that in the opinion, because in Trombetta, the court recognized this. The U.S. Supreme Court, 20 some odd years ago, noted this. And in fact, in New Hampshire, it's mandatory that they keep the samples. And there are products available for this. And finally, the court said that it doesn't significantly increase the embarrassment of the arrest. And I think that's completely unhinged from reality. And I placed a hypothetical in my brief about this, where you can imagine yourself, you're at a restaurant. And I thought in terms of, You haven't had a drop to drink. No one would even suspect you would. But either a child had your car, one of your children away at college had gotten some tickets and didn't tell you, or perhaps you had gotten a ticket parking somewhere over on Kansas Street and the wind blew the ticket off. You never knew about it. And lo and behold, a bench warrant issues. Officer sees you, comes in, you're eating with your colleagues. The officer can now make that arrest, make you stand outside in front of the restaurant, in front of all your colleagues, and wait 15 to 20 minutes. That officer can then make you sit there and submit to the breath testing in the van, door opened, for the world to see that you're having to do this. No suspicion that you've been drinking. You haven't even been necessarily driving. But that's what this categorical exception means. Any kind of arrest whatsoever. No suspicion of driving, no suspicion of drinking. They can make you submit to a breath test. And I think that that is wholly unacceptable in Kansas. Turning to the burdens, obviously the state has an interest in deterring drunk driving, but it claims the burden is going to swamp the courts. Kansas has been doing exactly this for the last 2 to 3 years, I think, especially since this case came down. And I don't see any news reports of how the Kansas courts are dying because warrants are issued in some of these cases. The reality is the court was assuming it cited the total number of DUI cases compared to the total number of judges. But the reality is, in most of these cases, arguably, people are submitting to the testing. So warrants only come up in a limited, finite, small number. But as the dissent pointed out, even using the numbers, you're only talking about, in those places, North Dakota and Minnesota, talking about 1 to 2 more warrants a week than normal. That's hardly going to swamp the courts. So I would just say that while other states may have issues, Kansas certainly does not in these circumstances. In some, because it looks like I'm out of time, other states have gone beyond the Fourth Amendment and said their state constitutions recognize more rights than the Fourth Amendment. Idaho doesn't have a good faith exception. Some states don't recognize pretextual stops from Wren. Michigan, the case where the DUI checkpoint law came from, doesn't allow for DUI checkpoints, ironically. And a lot of states don't allow arrests for minor offenses, which the Supreme Court said was okay in Atwater. So this is not something unheard of, and I think it's been 25 years since this court has done it. It's time that this court acknowledge that Section 15 actually means something unique in particular to the needs of our state. So for these and all the reasons I've cited before, this court should not modify its prior opinion, and it should affirm the district court's reversal in finding the statute facially unconstitutional.
Do we have any more questions? Thank you, counsel.
Law enforcement is trained to do breathalyzer test after arrest. I don't know of any case that this court has seen or any case pending before the Court of Appeals of the Kansas Supreme Court where it has not happened after a lawful arrest. But regardless, I don't have to prove, or the state does not have to prove that it's constitutional in every application of the potential application of the statute, just in some. And a lawful search and to arrest when there is a arrest counts. I think counsel is probably overreading Birchfield. Maybe we can expand Birchfield someday, but Birchfield repeatedly said, we conclude Fourth Amendment permits warrantless breath test incident to arrest for drunk driving. And every time they said it, they repeated for drunk driving. My counsel, or opposing counsel, is pretty much incorrect on most everything he said about how the breathalyzer works. They do not store samples. They could potentially, I suppose, from the breath pieces, but they're thrown away. I think if this court is seriously interested in how the breathalyzer works, probably neither party should be spouting their opinion, and maybe some kind of factual something should happen so that you're actually aware of it. But I can tell you that basically everything he said, I turned to my DUI expert and he was shaking his head no. That is not how it works. I think that I've made all my points. I would just respectfully ask that this court uphold the constitutionality of the statute and remand for further proceedings in this case.
Any questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement. Now